So now we are going to talk about plain smell doctrine. And what you have here is a pictorial representation of what you may plainly be smelling. Let's proceed on. Plain smell is somewhat akin to the plain view doctrine. A plain smell search and seizure is lawful when you're in a place where you have a right to be, when the evidence is discovered, and when it is immediately apparent to the officer that the items smelled constitute evidence of a crime or contraband, or are subject to seizure based upon probable cause and exigent circumstance. Because remember, you just had the pop quiz. You got to have PC for a search, but you can use exigent circumstance in lieu of obtaining the warrant. And the case we're going to examine this in is that of State v. Pickett. Now, in this case, the defendant's driving a vehicle stopped at a checkpoint, and you got the defendant and one other passenger in the vehicle. Deputy approaches and smells odor of marijuana coming from the window, which is open on the driver's side. Now, deputy testified, familiar with the odor of marijuana, but was unable to determine the exact location of the odor beyond saying it was coming from inside of the car. So, at this point, the officer orders defendant out of the vehicle and search them, locating cocaine residue on a dollar bill and a straw in the defendant's back pocket. Deputy arrested defendant, searched the vehicle, finding a bag of marijuana under the driver's seat and a handgun in a pouch on the back of the passenger seat. Obviously, at court, the defendant's going to argue a motion to suppress that the deputy did not have probable cause to search the defendant's person based on the smell of marijuana coming from the vehicle. Well, what do you think? Is that smell generally within the vehicle going to permit a search of the individual? Now, it's well settled that the odor of marijuana from the vehicle would have given the officer probable cause to search the vehicle and any containers inside the vehicle which may contain contraband. Because remember, one of the exigent circumstances has to do with removal of evidence. And is there anything better situated to remove that evidence than a motor vehicle? So once the officer had probable cause based on that plain smell that there was marijuana located within the vehicle, he could have searched it. However, there's always a comma but, the odor of marijuana from the vehicle in and of itself does not justify a search of an occupant in that vehicle. In this case, the court held the deputy did not have probable cause to search the person of the defendant. But remember, what the officer could have done is search the vehicle, and then upon finding the drugs under the driver's seat, could have, under the doctrine of constructive possession, if it's their registered vehicle, their seat, arrested the driver and then conducted a search of their person. Now, also when we talk about this general odor, that does not permit officers to search all of the passengers. You've got to have that individualized suspicion in order to search the person. Okay, well, I may have just given this one away. True or false? Odor of marijuana coming from a vehicle gives an officer probable cause to search an occupant of that vehicle. True or false? Alright, warrantless entry. Again, we are talking about intrusion into a space where there is a reasonable expectation of privacy protected by the Fourth Amendment. And to do that, you have to have two things. One, the requirement for probable cause, the Fourth Amendment standard, and an exigent circumstance, some emergency that is a justifiable reason for not taking the time to get a search warrant. The idea that there's some unusual or immediate action needed. So let's look at that of State v. Adams. Now in State v. Adams, two officers see the defendant driving a vehicle. Big whoop. However, one of those officers was familiar with the defendant because he had stopped the defendant and charged him with DWI a few months earlier, and knew that as a result of that previous DWI, that his license had been suspended. So they ran his tag and license and confirmed the license was still revoked. He had not been granted some limited driving authority. So at that point, they had a reasonable suspicion. They had more than reasonable suspicion, but that's the standard for investigative detention. The defendant was driving while his license was suspended. So they pulled into his driveway directly behind his vehicle and initiated a stop by activating the blue lights. And let me back up just a second and remind everybody that under North Carolina law, you can reasonably presume that the registered owner of a vehicle is the driver of that vehicle. And in this case, of course, the officers actually saw the defendant and were able to identify him based on that prior experience. So, by the time the officer activated the lights, the defendant had gone ahead and exited his vehicle and was heading towards his front door. At that time, after the blue lights had activated, the second officer instructed the defendant to stop and get back inside of his car. Defendant was not cooperative, so the first officer pursued the defendant, who entered the door and attempted to close it behind him. But that officer was able to hold the door open until the second officer got to where he was at. They then forced the door open and confronted the defendant just inside the doorway. During a pat-down, they found a bag of marijuana in his pocket. At that point, the defendant was arrested for driving with license revoked, possession of marijuana, resisting an officer, and based on further observations, again driving while impaired. So, obviously, the defendant challenged what happened. He contended that their entry into his home and therefore his arrest and any evidence obtained was illegal and should be suppressed. What do you think? And I'm sorry that first bullet popped up. I shouldn't have advanced the slide. as you can see, the decision of the court looked at the doctrine of hot pursuit. Now, I know typically we talk about this in terms of going from one agency's jurisdiction into another while maintaining continuous pursuit. But those of you who've had me for BLET know that we also talk about this in terms of entry into a residence while chasing a suspect. And here the court said, look, they had probable cause to arrest him for RDO and were in hot pursuit of him when they followed him into the house because he refused to heed the blue lights. And as you know, hot pursuit is an exigent circumstance sufficient to justify a warrantless entry. When there is that cause for consideration of immediate danger, such as a suspect barricading themselves or the potential for destruction of evidence. So they did have the ability, just because he went into his home, they could continue to follow him in. Now, interestingly, although we started talking about exigent circumstances, here the court said that the fact that it was merely a brief pursuit did not matter as to whether it rose to the level of an exigent circumstance. Essentially, that by maintaining that pursuit, they had the right to continue. So next up, CIs. And as you know, the courts have had difficult times with anonymous sources and occasionally CIs. And what you keep coming back to is, what information do we have and do we provide that can give that magistrate, that judicial official, confidence in the information being provided to them. Now, the standard being, evidence has to be in the record of a search application so that the court, the judicial official, can weigh the reliability of the informant's information. And that can include where the informant is making a statement against their own penal interest, where they've implicated themselves in criminal activity, as well as statements showing that the informant has a history of providing reliable information. Alright folks, welcome back. State v. Jackson. Let's talk about CIs. Narcotics officers conduct a knock and talk at the home of a person they had not previously met. And the facts in the outline say that the officers indicated to the person she could face criminal charges based on her possession of marijuana. I'm confused by that. It's a person they've never met. They're doing a knock and talk, so how do they know she's got marijuana? I have absolutely no idea. I've gone back and read the case and the briefs for both the defendant and the state, and they just skim over and say no more than that. So somehow the narcotics officers had the goods on the defendant and explained to her that she was at risk of criminal prosecution. That informant agreed to provide information about where she had obtained the marijuana and explained she'd gotten it from the defendant, who she described as a male in his early 20s with long dark hair. That lets me out. She did provide his name, spoke about having purchased marijuana from him on multiple prior occasions, and that she had most recently purchased it from him at his residence 2 days prior. Now, she explained how when she was in there, he had gone back to a bedroom on the right side of the house. She heard him turn a key in a lock and then return with a mason jar from which she purchased drugs. She showed a lot of knowledge as to the interior of the residence, and in fact showed the defendants where the home was. The officers checked on information they could find regarding the resident of that home, and it matched the physical description given by the informant. So, based on this, they applied for a search warrant, enlisting the assistance of a local deputy because these were city detectives and the residence was outside of their jurisdiction. So, in the warrant application, the deputy stated he received information on several occasions from other concerned citizens in the area regarding the premise to be searched about drug trafficking going on there. So the deputy supplemented the information provided by the law officers, corroborating essentially what they had to say about ongoing criminal activity. And when the warrant was executed, they found a marijuana grow operation. So what happens? And I'm not going to pull up the ruling slide yet because I don't need it popping out information. But the defendant argued that the information used to get the warrant was not reliable, because what they had here was a first-time encounter with a CI. So does that CI thereby have a history of providing reliable information? Obviously not. So are they otherwise a credible source of information? And here's what the court said. While the informant did not have that history, it recognized that her admission that she had purchased marijuana exposed her to criminal prosecution. It was a statement against her penal interest. Further, she spoke to them face to face, spoke from her first-hand knowledge, and because of that face-to-face encounter, the officers had the ability to evaluate her credibility. The court looked to the level of detail contained in her information, as well as the freshness of the information, which all of it considered to be relevant. Finally, you should note that the information from the deputy regarding other witnesses and complainants corroborated what the CI provided. So, due to the level of detail, the accuracy of her description of the home, the freshness and first-hand nature of the information, the court found there was sufficient indicia of reliability to support probable cause. Quick caveat: the defense has taken this case up for review by the Supreme Court. They have not, as of May 27th, issued a ruling in that matter. If one comes down, I will certainly update you.